first thing to know whenever you talk about United States Supreme Court cases, really any opinions, whether any kind of appellate decision or, frankly, any kind of trial court decision, is to really understand the context. I had probably one of the best constitutional law professors in the United States who taught me at Baylor, and his saying over and over was that constitutional law is really just a mirror image of society, and that it is a reflection of society at that point in time. And to understand the cases that come out from those time periods, sometimes even if you read a case from 20 years ago, you scratch your head and think, well, what in the heck were they thinking? That doesn't make sense. But you've got to think, most of you are too young, but, I grew up without cell phones, and these cases are inside of a context of totally different societies than we are now, and it seems like society changes so much more, even more quickly these years. I saw Twitter, they actually celebrated their 10-year anniversary. I've never tweeted, and frankly, I'm confused by the topic. I'm sure many of you in here probably do that, but just these small kind of contextual, historical perspectives helps you understand the cases. So the first case that we're going to talk about first is Plessy versus Ferguson. Raise your hand if you've ever heard just the name of that case. Okay, raise your hand if you've ever heard of the name of the case, Brown versus Board of Education. Okay, I really like that introduction. I worked with Sandra Day O'Connor, who is the first female justice on the United States Supreme Court, to bring a civics program to Texas, and her civics program is called iCivics.org. One of the things that she used to it fascinated her was people could name all the judges on American Idol, but they couldn't name a single judge on the United States Supreme Court. And frankly, I fall victim to some of these things. It's silly how much we get into pop culture and we can name all these things, but we don't know the most basic facts that are the very foundation of the law in this country and why we do certain things day in and day out. Why we have arguments. You saw Justice Antonin Scalia died recently. Why is it such an important spot to fill? Because it literally changes the nation whenever the court decides a topic, especially the important topics. The court decides every 10, 20, 30 years or so. There's something that's just revolutionary, really. Plessy versus Ferguson. To give you a little bit of background, and I don't have a whole lot of time, so I'm going to try not to make them bring out the hook and pull me off stage. A little bit of background. Plessy was a man who was 7/8 white and 1/8 black. And this is a style case that was actually done as a test case. The East Louisiana Railroad Company had cars, and Louisiana had passed legislation within a few years of this case that said that each rail car operating within the state of Louisiana had to have separate cars for whites and for blacks, or people of color is kind of how they phrased it in the law. And so the test case took Plessy, a guy named Homer Plessy, and they put him on that railroad who disagreed with the law because, one, I think it was because of the cost. They said, well, we have to do this to every train that's on the line. It's expensive. And so they agreed with a group of concerned citizens to let Plessy come on board, have a private investigator arrest him. The investigator was in on this whole scheme, and they arrested him as soon as he got on and took him off at the next stop. And that started the case. The case eventually, well, first of all the lower court said, this is perfectly legitimate exercise of the state's power. They can do this. When it got appealed to the United States Supreme Court, you're looking at a court from 1896. It's a totally different time from last time. In fact, something I heard recently in the late 1800s, William McKinley, the president, had said, well, to be president when he was campaigning, he said, I'm going to sit on my porch, in Canton, Ohio, and if anybody wants to interview me, they can come to my house. Now you see Trump and, you know, all these other guys out there texting and twittering and traveling the country. This is a totally different time where you can have a presidential candidate who wins sitting on his porch and not going campaigning because he doesn't want to. So during this same time frame, the court looked at this and they said, you know what? As the court, one, we're not going to say that equal protection applies here. Two, we're going to, you've heard the buzz phrase separate but equal, but they asked a few questions, and these are, you know, folks see decisions like this, and they think, well, I can't understand it. I can't wrap my brain around it. Generally speaking, judges, lawyers, anybody in their profession try to do the right thing, and they try to follow the law, and they're trying to get it right. Here, they, you know, in retrospect, they got it very wrong, and it caused a lot of problems which didn't get corrected until 6 decades later. So, ultimate decision here was it created the separate but equal doctrine, which was as long as the state has separate facilities, then and equal, then the Equal Protection Clause doesn't have anything to say about it. I think you had a bunch of, you know, old guys sitting in robes who hadn't experienced some of these things before, and they could not understand that in practice it was never separate but equal. Equal was almost a joke in many states. Now, some states, like Topeka, Kansas, which we'll talk about later, they tried hard, apparently, and that's what the trial court had actually decided they did. But I think the reality is it's inherently not equal, and that's what we heard Chief Justice Warren talk about later in Brown versus Board. I've got a couple pictures up here. Kind of as that Plessy versus Ferguson set the tone, it had already been set, but it really put a rubber stamp on states' ability to do this, and so it eventually, just like any other public open space, migrated to education. And in some senses, it had been around in many states in education for years and years, and it just reaffirmed to them that we ought to be able to do this. So you've got 17 states by the time Brown versus Board rolled around. 17 states required racial segregation, and 16 states prohibited